EU Regulation 44 per 2001 and its implication for the International Maritime Liability Convention. EU Regulation Number 44 per 2001 on jurisdiction and the recognition and enforcement of judgment in civil and commercial matters was adopted on 22 December 2000. It is probably fair to assume that few at that time realized the full extent of the effect that this instrument would come to have been felt outside the framework of judicial cooperation. By incorporating the 1968 Brussels Convention into European Community law, subject matters regulated therein triggered what is known as exclusive community competence, not only internally within the EU but also externally in relation to other states in line with the so-called AETR doctrine established by the European Court of Justice. Since matters relating to the jurisdiction, recognition, and enforcement of judgment are frequently regulated in international conventions, in particular those relating to liability and compensation, a number of conventions that had previously belonged to the domain of member state competence in this way became mixed, that is, where the competence is shared by the member state and the community. Member state liberty to act freely with regard to a number of conventions was hereby considerably limited under community law. The Maritime Liability Convention have been among the first in the line to be affected by this new shared competence and therefore provide an interesting case for studying the effect of this new situation and for analyzing the different solutions proposed to address it at EU and international levels. An analysis of the impact of Regulation 44 per 2001 on the Maritime Liability Convention is interesting too, in that the international agreement concerned have different relationship to Regulation 44 per 2001. The earliest of the convention considered in this article is the HNS Convention, which was adopted already in 1996, well before the community competence on judicial cooperation had been established but hasn't yet been ratified by the EU member states. The Bunkers Convention was adopted in April 2001, that is shortly after the adoption of Regulation 44 per 2001, but before its consequences were fully understood. These two conventions have recently been at the center of a discussion relating to the management of the new situation within the EU, which will be dealt with in Section 3 and 4 below. Since the adoption of Regulation 44 per 2001, new maritime liability agreements have been or are being negotiated with the new shared competence in mind. Those agreements and the solution envisaged for them are dealt with in Section 5. Some concluding remarks relating to potential short-term and longer-term implication of Regulation 44 per 2001 for the community's international activities in maritime affairs appear in Section 6. The Treaty of Amsterdam included a new Title IV into the EC Treaty containing specific provision on judicial cooperation in civil matters. Following from this new competence, the European Council in October 1999 established the enhanced mutual recognition of judicial decisions and judgment would facilitate cooperation between authorities and the judicial protection of individual rights and agreed that the principle of mutual recognition should become the cornerstone of judicial cooperation in both civil and criminal matters within the Union. One of the first EU regulatory measures to result from this effort is Regulation 44 per 2001, also known as the Brussels I regulation, which covers all areas of civil and commercial law except for those that are expressly excluded from its scope. It lays down the rules on jurisdiction for a variety of different matters and is largely based on the principle that jurisdiction is appropriate in the state of the defendant's domicile. In matters relating to tort, delict, or quasi-delict, a person domiciled in a member state may be sued in the member state where the harmful event occurred or may occur. The regulation further contains specific jurisdiction rules relating to insurance, consumer contract, and employment where the weaker party needs particular protection. Recognition of a judgment given in one court of an EU member state is automatic in another member state unless contested. Similarly, a declaration that a judgment is enforceable is virtually automatic after purely formal check of the document. Enforcement can be refused only on one of the grounds exhaustively listed. This procedure is therefore less complex than would generally result from application of national law. When it comes to the relationship between this provision and international agreements which govern the same subject for particular matters, Regulation 44 per 2001 represents a small but significant change to the regime that applied under the 1968 Convention. While such international conventions were given a general precedence in the 1968 Convention, Regulation 44 per 2001 limits this exception only to conventions to which the member states are parties at the time of the adoption of the regulation. In brief, therefore, the adoption of Regulation 44 per 2001 resulted in a significant set of new rules being brought into the realm of community law. For the purpose of this article, the most important consequence of this is the resulting exclusive community competence, which implied significant limitation on the possibility for EU member states to enter into international obligation on issues that could affect the rules laid down in Regulation 44 per 2001. Implication in the maritime field. The international maritime community is probably among the most sensitive toward regional or other unilateral initiatives in regulatory and political debates. The argument vigorously maintained by both the maritime industry and a considerable number of governments is that a global business where the players so easily can choose the jurisdiction of their operation needs to be regulated at global level in order to avoid a patchwork of standards in various geographical areas, which would result in distortion of competition and a series of legal and practical difficulties. Partly for such reason, frequently strongly defended also in the Council, the European Community hasn't been in a position to exercise the full potential of the competence acquired by an ever-widening set of measures regulating maritime safety and pollution control. It is only in the last 5 or so years that the practice of EU coordination of member state position ahead of international meeting has become generally established in the maritime field. And even then, the community has generally satisfied itself with a less formal and less committing form of coordination of position than a strict reading of the EC Treaty would suggest. Perhaps symptomatically, It took a regulation in a completely different field to trigger a more formalistic way of handling maritime issues falling within the exclusive community competence at the international level. The implications are considerable, as 10 of international conventions or protocols in the maritime field alone may be implicated by this new mixity. Thank you.